Yes, Mr Murphy.
Assistant Commissioner, my name is Murphy. I'm one of the lawyers here in Kumanjayi. Do you agree that one of the essential functions of a police complaint system is to maintain community trust in police?
Yes, I do. Excuse me. Yes, I do.
Do you agree that trust is built up over time by a well-functioning police complaint system?
Yes, I agree with that.
And do you agree that that trust can be lost over time by a poorly functioning police complaint system?
Yes, I agree. It can be lost. Yes.
Just ask the court staff to pull up the first document that I wanted to refer to today, which is at 13-1 of the brief, which is, as you can see at the heading there, report of the inquiry into the death of Jabanavi. This is a document associated with the Royal Commission into Aboriginal Deaths in Custody, in which Commissioner Johnston QC looked into a particular coronial inquest. And I want to give you one page for context and then ask you to reflect on another page. The page that I'd like to take you to is page 40, so page 52 of the PDF, which is page 41 down the bottom, just the previous page. Thank you, court staff. And just under the heading Complaints Against Police, Commissioner Johnston reflects on evidence and concerns that were raised at the inquest. And I just ask you to read that to yourself so that you're aware of the context in which the subsequent remarks come. And you can let me know once you've finished reading that.
Yep.
And I'll just ask the court staff to move to the next page, and I'll read out one passage and then another and ask you to reflect on each of them. But just ask.
I'm done reading. Sorry.
So the second paragraph reads, "It's clear to me from consultations and investigations which I've conducted during the course of the Commission that the question of the establishment of an effectively and demonstrably fair complaint system is a very important matter in the minds of Aboriginal people who have frequently raised this question." Do you agree, and I should say this report's published in 1991, do you agree that the effective running of a police complaint system has been a matter of concern to Aboriginal people in the Northern Territory for over 30 years now?
Yes, I agree.
And relatedly, in the next paragraph down, Commissioner Johnston said, a related topic is that concerning the even-handedness of police investigations into the conduct of police. In my opinion, no fair-minded person could read the findings of fact and reasons for decision of the coroner in the Tea Tree case without feeling a great unease about the apparent differences in approach adopted by police investigators in scrutinising the conduct of Aboriginal participants in the events on the one hand and the conduct of the two police constables on the other. Do you agree that the perception of bias or differential treatment by police investigating police has been an issue of concern to Aboriginal people in the Northern Territory for over 30 years?
I agree that that's a perception, yes.
And that that's been a concern?
That's a perception, yes.
And do you agree, having heard, were you in the court for the evidence of Ms Little this morning?
For part of it, not all of it.
Did you hear Ms Little give evidence that during consultations she's conducted with Aboriginal community members, that there is still until this day a concern about the fairness and independence, I'm paraphrasing, but the fairness and independence of the police complaint system in the Northern Territory?
Yes, I heard that evidence.
Do you agree, and I'm asking this in the abstract because I appreciate you, well, I expect you won't agree that we're at this point, but do you agree that theoretically there's a point at which it has to be acknowledged that community trust in police has been eroded for so long and so fundamentally that a radical change is required in the police complaint system?
No, I don't agree with that. but I agree that there needs to be change of the system.
So you don't agree that there comes a point where there needs to be radical change? I'm not saying we're at it now, but do you agree theoretically that there could come a point where trust is so eroded that something radical needs to be done to change the system?
I don't agree that trust eroded as in that is what's being reported, but that is not what I've been seeing myself. But there is a need to have a change to the system where we can be equitable to any complainant, no matter whether they're Aboriginal or otherwise.
And is it your evidence that that change can really come about by giving effect to, with consultation, the Galliot report?
Yes, that's correct.
I'll return to that at the end of my questions, but I'll just ask you about a few of the incidents you've given evidence about. And the first one, I'll ask you about four. The first one is the 2nd of April 2017, which is the fist fight outside Bojangles, and then an incident in which I think it's uncontroversial, it is uncontroversial, that Constable Rolfe tackled a man to the ground, to bitumen, and for which the man was ultimately given an infringement notice. I could ask the court staff to bring up a section of the transcript from your evidence on Friday. And perhaps if the court staff could scroll down. You agree that this, before I ask you about the transcript, this is an incident where Constable Rolfe did not have his body-worn camera on. You agree with that?
Yes, I agree.
And when you were asked, I'll just ask the court staff to scroll down slightly more so we can see the whole of that final answer. When you were asked about this incident by Dr. Freckleton, you referred to the assessment of Sergeant Barron, but the particular bit of the answer I'm focused on, but I'll allow you to read it for context, is the last two sentences which start, without body-worn footage, because there was no body-worn footage available to make an assessment, you have to take the words of the member. The member at the time is, I couldn't fully myself ascertain that it was not reasonable and necessary in the circumstances, just because of the outcome of the ticket to the offender. Do you agree that the evidence you gave then was that in the absence of body-worn footage, you understood it to be the case for yourself that you have to take the words of the member? Do you agree that's the evidence that you gave? No,
I don't agree, because on the review of that, it wasn't just the one member. There's also the evidence of the other member. That was.
So, did you misspeak when you said? It certainly looks like you're trying to convey there that if there's no body-worn footage, you have to take the words of the member. Was that sort of an imperfect expression?
Yeah,
your approach?
That wasn't the intent.
Okay. I'll put it to you that your answer there was organic in response to a question by the council assisting the police force, and that is reflective, generally speaking, of the police approach to complaints in which body-worn camera footage is not available. Do you agree with that or disagree with that?
No, I disagree with that. If there's other evidence to support either way.
I'll just ask you then about your approach to this incident, or rather your finding. You found that it was not possible to determine whether the force used was reasonable, necessary, proportionate, or appropriate in the circumstances, owing to a lack of information. That's right?
That's correct.
And
sorry, it's gone.
No, that's right. I don't need to refer to it anymore. Thank you. And Detective Sergeant Barron, however, reached a different conclusion, and that was that the force was not reasonable. That's right?
Yes.
And Detective Sergeant Barron's finding was based on his conclusion that, quote, force was used when it could have been avoided, end quote. Do you agree that that was his basis for the finding?
I think the basis of his finding was that force could have been undertaken another way.
I'll ask you to turn up to your first statement at paragraph 53.
Sorry, my first affidavit.
Your first affidavit at paragraph 53. And you say there that you've said you agree with Detective Senior Sergeant Barron that in choosing to pursue the male, this ultimately led to a situation where force was used when it could have been avoided. Do you agree first that that is your understanding of the basis for Detective Senior Sergeant Barron's finding?
Yes, that's the basis, but there was further, which is in my affidavit, on his assessment of that matter.
The coroner has his affidavit. But so you've said that was at least part of the basis for Detective Senior Sergeant Barron's finding. But you also agreed with that. You agreed that in this incident, force was used when it could have been avoided. You agree with that?
Yes, there could have been other options.
Can you explain to the coroner how it is that where force could have been avoided, you didn't reach a conclusion that it was unnecessary?
No, because I cannot determine what is in the mind of the police officer at that particular time.
And is it your view that in assessing the necessity of a use of force, you need to get into the mind of the police officer at the time?
No, because you're going on the evidence of the police officers provided. But the reality of is in this instance, you have a person who has committed offences, a person who is escaping from police. The police officer used force to apprehend that person, and I cannot find that in the circumstances, without any other information, that force was not unreasonable in the circumstances.
I'm just focusing on the word necessary. Could you tell the coroner what your understanding of the word necessary is in terms of it being a criterion of the lawful use of force or the proper use of force?
Yep, so necessary is, was it necessary, so was it a requirement to undertake that particular course of action in that circumstance?
Do you agree that the ordinary meaning of necessary is that it was needed or essential?
Yes.
Yeah. And do you agree that in circumstances where the force could have been avoided, it cannot be said that it was essential?
I can't say that because is it essential to apprehend the offender who may have committed assault on another person, which is the visual incident that the members were faced with.
I've taken that as far as I can, but out of fairness, I'm going to put to you that your approach to that incident is reflective of a police-orientated mentality or a pro-colleague bias that insufficiently values the interests of the complainant. What do you say about that?
No, I do not agree.
I'd like to take you now to the incident of 11th of January 2018. This is the Malcolm Ryder incident. This is an incident where as a civilian who wasn't initially the arrest target sustains 2 head injuries requiring a total of 13 to 16 stitches. There's differing evidence about how many stitches, and was ultimately hospitalised. Do you agree, and I'm not asking you to remember the specific words, but that do you agree that this is a general understanding, your general understanding of what the local court judge's findings were in relation to the criminal proceedings that resulted out of this? And for everyone else's benefit, I'm reading from the second Barham affidavit of paragraph 41, where it's extracted, quote, how the injuries occurred and in what sequence of events is more likely than not to be in a manner consistent with Malcolm Ryder's evidence. That is, Rolf deliberately banged his head into the floor as he was being turned over to be handcuffed, end quote. Is that your understanding of the local court judge's findings in the related criminal proceedings?
Yes.
And in the face of that, what you rely on to say there was insufficient evidence is that there were conflicting accounts. Do you agree with that?
Yes. When you say conflicting accounts between Mr. Ryder and the police officers present?
Yes.
Yes.
And if you need to refer to paragraph 69 of your affidavit, you can, but I think you've agreed that that's the matter that you relied upon. Do you agree, though, that in all or almost all use of force complaints, there's going to be conflicting accounts unless the police officer admits that they've used excessive force? Do you agree that in all or many use of force complaints there's going to be conflicting accounts?
Yes, I agree.
Do you agree that there were conflicting accounts before Judge Borges in the related criminal proceedings?
I wasn't at the proceedings and I haven't seen the full transcripts, but that's the indication, yes.
Yeah. Did you not review the full transcript when you were reviewing this use of force subsequently?
No, my Professional Standards Command reviewed the full transcripts.
But as you understand, I think you've said there have been conflicting accounts before Judge Borchers. You agree with that?
Yes, I agree.
And obviously, on your understanding of Judge Borchers' findings, he was able to resolve those conflicting accounts.
Can you explain that, please?
As in, notwithstanding the conflicting accounts, Judge Borchers was able to find it's more likely than not that the injuries were sustained in a manner consistent with Malcolm Ryder's evidence. You'd agree that Judge Borchers was able to resolve the conflicting accounts.
That was the judge's assessment at the time, yes.
But you and the PSC were not able to resolve the conflicting accounts, that's right?
Yes, that's correct.
Put to you out of fairness that your or the PSC's inability to resolve the conflicting accounts in circumstances where a local court judge has is indicative of a police-orientated mentality or a pro-colleague bias, and it shows insufficient value for the interests of the complainant. What do you say to that?
No, I do not agree. Is we done further investigation or crime come under further investigation and it was unable to be determined.
I'll move on to the third of the four incidents that I want to ask you questions about. This is in relation to CW on Anzac Hill, and it's the 1st of April 2019. Here we have another Aboriginal man, or in fact it appears a youth, who ends up bleeding from the head after being arrested by Constable Rolfe. Again, we have no body-worn footage from Constable Rolfe. You determined, quote, that, quote, there was insufficient evidence to establish whether the use of force was excessive, given the only available evidence was the conflicting accounts provided by Constable Rolfe and, I won't use the person's name, I'll say CW. That was your determination, that's correct?
Yes, that's correct.
To return to something that I just asked you, you're aware that in any fact-finding process, including fact-finding processes that occur every day in the courts in the Northern Territory, surrounding evidence can be taken into account to prefer one account to another?
Yes, that's correct.
You'd agree that that makes sense as a matter of logic and fact-finding?
Yes, I agree.
Okay. Would you agree that the following categories of surrounding evidence are potentially relevant to whether a fact finder prefers one account to another? First, the fact that the alleged wrongdoer has attempted to avoid or appears to have attempted to avoid scrutiny. Would you agree that would be relevant to whether or not you accept their account?
I can't determine whether he attempted to avoid scrutiny or
Oh,
not.
sorry, I'm just asking as a matter of principle. I mean, you're obviously engaged in fact-finding and drawing inferences from facts. Do you agree that as a matter of principle, the fact that someone's attempted to avoid scrutiny is something that might cast doubt on their complaint, on their account?
Yes, I agree.
And as a matter of principle, by contrast, do you agree that the fact that someone's made a prompt complaint, or really an immediate complaint, can be a matter weighing in favour of preferring their account?
I don't agree with that because I've had numerous instances where complaints been made and there has been no evidence to support it at all.
I'm just asking generally speaking, so I'm not saying that in every case where someone makes a prompt complaint. I'm asking you, as a person who's engaged in fact finding, you agree that can be one matter that points in favour of supporting their complaint?
No, I don't agree.
Okay. Do you agree, though, that if there's consistency in a person's complaint as they give it over time, for example, if they give it once and they give it a subsequent time and there's no changes in it, that can be indicative of the truthfulness of that account?
Yes, it can be taken into account.
And I'll just then turn to the contrast when you're reviewing the account given by the police officer, or really anybody in any fact-finding incident. Do you agree that if someone has a demonstrated tendency to act in a particular way in the past, that can throw some light on, potentially, how they acted on the instant occasion that you're reviewing? Do you agree with that?
No, not particularly.
Have you had any training in fact-finding or inference?
No, I do, but you've got to take every incident into account. And just because someone has tendency that they've done certain things, that does not mean that they've done it then.
Sorry, I might not have given the question clearly enough. I'm not asking you whether or not it means conclusively that they've done the thing. I'm asking you whether that can be relevant.
Yes, it can be relevant.
Do you agree, the converse of what I've asked you about consistency in a complaint, do you agree that when you're reviewing a police officer's account, that if there is inconsistency within that account, for instance, if they've said one thing at one time and then later on they've said something else, that can tend towards casting doubt on the veracity of their account?
Yes, it can be.
And would you also agree that to the extent that police officer's account is inconsistent with the external evidence, that can cast doubt on the veracity of their account?
Yes.
In this incident, to go through each of those, did you take into account the fact that Constable Rolfe had deactivated his body-worn camera before the alleged use of force?
I don't think he actually put his camera on off the top of my head.
I think you'll find that he deactivated it as he was walking into the grass in Anzac Hill. But it sounds that you're not sure.
Irrespective, he did not have his camera on.
And was that a matter that you positively took into account as potentially showing an intent to avoid scrutiny?
No.
Was the fact that CW made an immediate complaint to police caught on Constable Rolfe's partner's body-worn camera, was that something that you took into account?
The issue is I'm not the one that took these things into account. It's my professional standards investigators. But it would have been taken into account, I imagine.
I'm asking, I appreciate that you didn't do the initial PSC review, but you have come to this court and sworn an affidavit attesting to your confidence in particular findings that they've made. And so it's on that basis that I'm asking you the questions. I've asked you about the promptness of the complaint. Do you think the PSC would have considered, or rather, did you consider?
Should they have?
I think given that this Assistant Commissioner is here as the face of the PSC, I think it would be hoped that his approach is indicative.
Sure.
So, as you were reviewing these matters, this matter in particular, did you take into account the consistency in CW's complaint, namely the fact that he made it on the body-worn video and then he made it again in the record of interview?
Yes, that was his account.
Did you take into account the fact that there was consistency there over time in the complaint?
No, I did not.
Did you take into account the fact that 6 weeks earlier, Constable Rolfe had pushed over 2 men in what you, as I understand it, agree was an excessive use of force? Was that taken into account in determining whether or not to accept, or whether or not a finding could be made on this occasion?
Sorry, did you say 6 weeks later? 6
weeks earlier, Constable Rolfe had pushed over 2 men, as I understand it.
No, this person wasn't pushed over from what I can gather.
But isn't that exactly what you investigated?
No, he was apprehended.
And his face made contact with the ground, that's correct?
Yeah, that's correct. But whether he's pushed over or whether he's ground stabilised, we don't have the evidence to determine that.
Well, even Constable Rolfe doesn't say he was ground stabilised. I mean, he says he fell over, right?
That's correct. That's what we're saying. There is no body-worn evidence to determine exactly what happened at that point in time.
Okay. I apologise I'm taking so long with this, but this is intended as one illustration. I won't be doing this for the remaining complaint that I'll address. Did you take into account in reviewing this use of force what appeared to be inconsistencies between Constable Rolfe's version and the external evidence? And I say that because Constable Rolfe, in his statutory declaration, which is accepted at 3-079, page 5, stated that he and Sergeant Kirkby arrived at CW at the same time, whereas the body-worn footage of Sergeant Kirkby clearly shows that wasn't correct. Did you take into account that apparent discrepancy?
No.
Okay. Did you take into account what appears to be an inconsistency in Constable Rolfe's versions, and it might be a minor one, but the fact that on the body-worn footage of Sergeant Kirkby, Constable Rolfe says that CW had, quote, fallen over in the dirt, end quote, whereas in his signed statutory declaration, he suggests that CW had, quote, dived, as in gone to ground to try and hide from police. Did you take into account that apparent inconsistency in Constable Roll's version over time?
Yeah, we took into account but could not determine either way as to how the Mr. went to ground.
It's not about what you could determine, and I know it's late in the day. It's about whether or not you took these matters into account in determining whether or not to accept or be persuaded by certain evidence.
No, I did not take into account.
So, for example, if a complainant comes along and gives two different versions, that would be perhaps a reason to say that they're unreliable or inaccurate, and therefore I couldn't accept their version.
That's correct.
And the same for a police officer who gives different versions in his accounts. You would then be able to conclude, I couldn't accept the version of that police officer.
I understand, Your Honour.
I put to you that your approach as the head of the PSC to this complaint or to reviewing this complaint and the matters that you did and didn't take into account demonstrates the complete ineffectiveness for purpose of the PSC as a police complaint system. What do you say to that?
I do not agree.
And I put to you as a matter of fairness that not only does it demonstrate that, it demonstrates, and I'm not saying conscious, but what appears to be subconscious bias of police investigating police to be biased towards their own colleagues. What do you say to that?
No, I do not agree.
The final incident that I would like to take you to is the incident of the 24th of September 2019, which is when Constable Roll chased a person down the Pod Mall who ultimately turned out to have done nothing wrong apart from run from police. This is an incident again where you've come to one view and Detective Sergeant Barron has come to another. Do you agree with that?
Yes, I agree.
Given that this event was recorded on body-worn footage, at least as to what is recorded, there's no factual doubt about what happened. It's about the perception of what was reasonable. Do you agree with that?
Yes, I agree.
Counsel Assistant Dr. Dwyer asked Superintendent Vickery some questions about this incident, and Superintendent Vickery said that, quote, different people will have a different view of what they see, end quote, and that was at transcript 305.3. Do you agree with that different people will have a different view of what they see on the body-worn footage of this incident?
Yes, I agree.
And you agree that different people might come to different views about what's necessary, proportionate, appropriate or reasonable in the circumstances based on that body-worn footage?
Based on their assessment of the body-worn footage, yes.
And do you agree that given the possibility for these different views, part of the explanation for that's got to be the reviewing person, the assessing person's own background experience, what they're taking into account when they're assessing the footage that they're viewing and deciding whether it's reasonable? Do you agree with that?
Yes, I agree.
And in those circumstances, don't you agree that there's a risk that police, when they're reviewing the conduct of one of their colleagues, will bring to it some subconscious bias in favour of that colleague and won't sufficiently account for the interests of the complainant? Do you agree with that?
Yes, there's always a risk.
There's always a risk when the investigation is being done internally in the police. Do you agree with that?
No, I don't agree with that.
Well, I think you just said there's always a risk.
No, there's a risk. You're saying the supervisor looking at the footage, but when we do PSC investigations, it's not just us looking at the footage, it's also the Office of the Ombudsman doing that assessment as well, so they have that independence.
You said in your statement that, and this is at paragraph 109, that, quote, the review of Constable Roll's use of force incidents had identified that supervisors have at times assessed the use of force as appropriate even when the force used is excessive. Do you agree that that's what the evidence shows?
Yes, I agree.
And is it fair to say that you attribute that to really those overseeing police having a lack of the proper training and a failure to follow procedures? Is that right?
No, I don't agree that they've had the lack of proper training.
How do you explain the fact that multiple supervisors have assessed use of force as appropriate, even where the force used is excessive?
I actually can't explain it. I can understand, understanding though I do not agree, supervisors, but they form relationships, which is why we have now implemented the independent subject matter expert review, but I cannot explain as to why a divisional superintendent has not determined that those incidents are excessive in the circumstance.
You can't explain it, but can you exclude the possibility that it is part of the explanation that police are reviewing the conduct of another police officer, a colleague?
No, I can't determine that.
So you can't rule out that there may be some colleague bias or police bias that's contributing to these failures to find that use of force are excessive. You can't rule that out.
No, I can't rule that out.
And certainly you'd agree with what Deputy Commissioner Smallpage said on Wednesday, that police are, quote, a fairly tight-knit group of people, end quote. That's from transcript 4153. You agree with that?
Police in general, yes.
And you don't see a problem with members of a tight-knit community being responsible for being involved in the disciplinary proceedings of other members of that community?
Well, generally when we do a complaining investigation, it goes out to the command. It is someone else who's not the supervisor or manager of that person doing that investigation.
They're still part of the tight-knit police community, that's right?
Yeah.
I want to ask you a few questions now about concerns that have been raised by international bodies and the like about the impartiality of police investigating police. And I'll ask the court staff to pull up a document that is, and I'm not going to take you to this document, it's just a convenient point to identify these quotes. So it's an expert report that's been filed by NARJA. I'm not going to, the only reason I'm taking you to is because there's some quotes there that I'd like you to comment on. And the first is the inset quote from the UN Human Rights Committee, and the reason I'm asking you these questions is about this idea of impartiality. So the first inset quote there, I'll just ask you to read that.
So is that Mark 21?
Yes, that's right. I assume you disagree with there being any necessary need for concern that reports of excessive use of force are investigated by police itself. You disagree with that being any source of concern necessarily?
Yes, I disagree.
And you disagree that it's necessary to establish a mechanism to carry out independent investigations, is that right?
No, well, there's already independent oversight in relation to matters.
On that issue of oversight, I'm satisfied with your answer there to the extent that it's illustrative. Could I ask the court staff to move to the next page? When you say independent oversight, you're referring to the Ombudsman?
Well, I'm referring also to Fresh Standards Command. So you have, if it's been investigated in the field, it's reviewed by the Fresh Standards Command, and it's also reviewed by the Office of the Ombudsman. And if they're unhappy with how that investigation is going, they then make recommendations for further.
The the Ombudsman has essentially, for at least a lot of the complaints, a supervisory function rather than the employees of the Ombudsman actually doing the investigating. Is that right?
Yes, they don't do the investigating, but they look at every aspect of the investigation.
Could I ask you to read the first inset quote there, starting with the word supervision, from the European Court of Human Rights? I assume you disagree that supervision by another authority is an insufficient safeguard of the independence of an investigation. I've got about 3 negatives in that, so I might reframe it for you. But would you agree that supervision by another authority is an insufficient safeguard? It's got to be fully independent external investigation. Would you agree or disagree with that?
No, I disagree that there needs to be a fully independent investigation.
Just in a few minutes before 12:30, I'd like to ask you a few questions about, while this document is still up there, not actual impartiality, but perceptions of impartiality. So whether or not this complaint process that might be characterised as largely internal to police, I know you might cover with that, whether or not it's actually impartial, I'm going to ask you to reflect on whether it might be perceived to be biased. You'd agree that perception is important. I think you said that at the start of your evidence.
Yes, anything can be perceived.
So do you agree that community perception of really the fairness and even-handedness of a police investigation, a police complaints process is important?
Yes, it is important.
The coroner has before her a report of an inquiry that was conducted, they're called the Stephen Lawrence Inquiry in the UK, and it comes to a different view to the one that I understand you've expressed. It was an inquiry headed by a judge of the High Court of England and Wales, a retired Deputy Chief Constable, a bishop and the chair of the Jewish Council for Racial Equality. And it found, and I think this is potentially on the previous page, court staff, in the inset quote under "in his landmark report," it found in the bottom sentence of that, investigation of police officers by their own or another police service is widely regarded as unjust and does not inspire public confidence. Do you agree that investigation of police by police doesn't inspire public confidence?
I agree that that can be the perception, yes.
And you agree that that can be a problem then?
Yeah, I agree that there needs to be trust with the community because police are the custodians of integrity, and we need to have the trust of the community in everything that we do.
When you say police are the custodians of integrity, what do you mean by that?
So everything that police officer does, so as in code of conduct, integrity is the core to being a police officer. So we are the ones that have to demonstrate integrity and honesty at all times, as per our oath.
But when you say custodians of integrity, are you...
It's my terminology, sorry.
Well, it aligns, if I can say respectfully, very close to the Gallant Review's assessment, which is that, is it your understanding that part of the Gallant Review looked at a civilian control model of police complaints but thought that it wasn't practical because it removed an organisation's control of their integrity issues?
Yes, I agree with that.
And is that what you were trying to get to there about the importance of police being custodians of their own integrity?
No, the importance, well, it is, as in we need to supervise and, because as supervisors and managers, we manage our people, we need to ensure that our people are doing the right thing, so we are the custodians of integrity to examine and make sure that our staff are doing the right thing.
Your Honour, I've probably got about 5 minutes.
Can you sit for another 5? You're going to have to come back tomorrow, but if you're tired, you should just come back tomorrow.
It's fine, Your Honour.
All right, we'll try and finish
Yes.
your evidence, all your questions, Mr. Murphy.
In term, you acknowledge, I think you acknowledged it earlier in your response to questions by Dr. Freckleton, that there is a problem at the moment with community confidence in the police complaints system. You'd agree with that?
Yes, I agree.
And your evidence, well, would you agree that one potential response to that would be to establish a completely independent body to deal with complaints?
That is one possible response, yes.
But you'd adopt, would you, the Gallant Review's response to that, which I just read to you, and this appears at page 30 of the Gallant Review, that third oversight model of civilian control has limited practical application in policing jurisdictions, as this model removes an organisation's control of their integrity issues and is limited in its capacity to influence management or policing culture. Is that why you wouldn't support a model of civilian control?
Yes, I do.
That's why you wouldn't support, that's the reason?
That's why I wouldn't support, yes, correct. Your Honour.
And what you'd support is something like the quote new professional excellence system that the Gallant Review suggests from page 122 of that review onwards, is that right?
Yes, that's correct.
Could I just ask the court staff to bring up an appendix to that review, which appears at PDF page 247. So PDF page 247 of the third affidavit of the Assistant Commissioner. And if I could, Assistant Commissioner, it's at page 168 of the Gallant Review, if you've got that in front of you while it's being brought up.
Yeah.
This model of new professional excellence that the police in principle support, and I understand that you've just said you support, is it correct? Well, at least it's depicted in Appendix 3 to the Gallant Review, is that right, in a pictorial form?
Yes, that's correct.
And from my review of that, is it correct that the only reference to the Office of the Ombudsman is on the top left-hand corner at the intake string and upper middle of the page where there's a reference to the Office of the Ombudsman semicolon random audit role only? Am I missing something there, or is that what that appendix appears to suggest?
That's what it appears to suggest, but we're still yet to examine and fully digest that model.
Okay.
Can you just tell me where that is, that random?
It's the third dot point down in the middle of the page, not in any box.
Okay.
Upper middle of the page.
Yes, I can see that.
I should note, Your Honour, that and it might be a matter for re-examination, but there is reference to the Ombudsman having what appears to be something more than a random audit oversight role earlier in the report. Perhaps it just is indicative of uncertainty about exactly what that role will look like. But my question to you, and no need to bring that up, Court Staff, Assistant Commissioner, is that model represented by that chart, or in fact by the Gallant report, that's been preferred over the civilian control model, that's right?
We really have not determined fully because we need to have consultation with all stakeholders as to what would be the preferred model.
Okay, but the Gallant report has preferred it, and NT Police have indicated in principle agreement with the Gallant report, that's right?
Yeah, we've agreed in principle to the recommendations, to consider all the recommendations. As stated previously, there still is a lot of work to be done in consultation with stakeholders as to what would be a suitable and achievable model to implement.
Okay, I've got about 3 questions left, and one of them is that the reason, or do you agree that the reason that Commander Gallant didn't prefer the civilian control model is shown at middle of page 149 of the Gallant Review, and I'll just read that out. The review considered recommending that high-level investigations be undertaken at the Office of Ombudsman, consequently generating complete independence. However, it's apparent there is limited capability in the local community with the requisite skill sets for these roles, and current investigative expertise and specialist resources lie within the Northern Territory Police. Is that Do you endorse that as being one reason that it appears that it's better that police are the ones investigating these high-level investigations?
Yes, I do, because the police currently have the investigative ability to do in-depth investigations and get data. The Office of the Ombudsman currently does not have that resource.
My final question, and if the court does have time to bring up recommendation 226 from the Royal Commission into Aboriginal Deaths in Custody, while I'm asking it is...
Recommendation
226. Assistant Commissioner, I'm going to put to you, and it's not a memory test, I'll try and bring this up onto the screen, that one of the recommendations of the Royal Commission 30 years ago that traversed some of the same issues that this coronial inquest is traversing is that, quote, that complaints against police should be made to, be investigated by or on behalf and adjudicated upon by a body or bodies totally independent of police services, end quote. There's a lot more detailed recommendation about there, and I should say in fairness it includes the possibility of police being involved in the investigation but certainly not adjudicating upon the complaint. If you take it from me that that was one recommendation 30 years ago, would you say that the proposed model of the Galliot Review is totally independent of police services?
Sorry, I'm not quite sure what you're asking there when you say totally independent of police services.
Would you say that the people adjudicating upon police complaints under the Galliot model, if that's implemented, are totally independent of police services?
Yes.
Are you saying that in reference to the people in the Office of the Ombudsman?
Yes, that's the only independence at the moment.
Yes, but not...
Other than the Independent Commission Against Corruption.
But not the police who are involved in reviewing the complaints and determining the complaints that don't go to the Ombudsman. You wouldn't say that they're totally independent, would you?
You can't say they're totally independent, no.
Those are the questions, Your Honour, and I apologise to the witness in the court for the time.
Thank you. Just before we adjourn for the day, Dr. Dwyer, what's the plan for tomorrow?
The plan for tomorrow, Your Honour, with great thanks to the current witness for his flexibility, is to start with Professor McCulloch and then to move to Mr. McDevitt, and it's anticipated that Assistant Commissioner Porter would return on Wednesday. We were going to ask my learned friends appearing for the Northern Territory Police whether or not Assistant Commissioner Porter would make himself available tomorrow afternoon in the event that those witnesses finish early. But we appreciate that Assistant Commissioner Porter has a lot of other obligations to attend to. So we'll continue to have those discussions. But it's very difficult to estimate those first two witnesses. They could take all day, they could finish a little early.
All right. Then we'll... sorry, did you want to say something?
Dr. Dwyer's finished, I said two brief matters.
Sure.
The first is that at 10 o'clock tomorrow I need to be back at a court for a remote appearance today on another matter. If I could be excused at that time when my phone rings. The second one, Your Honour, arises, and I'll only speak to it briefly, from the application that was made last Monday by Mr. Bowe in relation to the contempt. And I raise this now in terms of timing because I can say from my client's perspective the accusation is rejected and the application ought to be dismissed, both in terms of an allegation of contempt and an allegation of attempt to pervert the course of justice.
Sorry, did I make a ruling that there should be submissions in writing?
Your Honour, I simply raise this point. At paragraph 16 of Mr. Bowe's latest submissions, he says that every party should be given an opportunity to be heard. But he then goes to say that the procedure you might adopt is the first reading that you identify with particularity the conduct which you propose to make a referral or complaint. And then, if you were proposing to do so, allow parties to supposedly alleged to engage in that behaviour to the opportunity to make submissions. I simply raise it now, Your Honour, in terms of timing, because it might be that Ms Campion and Ms Credlin and Mrs Rolfe want to be heard before Friday, and I'm not sure whether or not they've been informed from the court about the application so that they can be represented either in court or in submissions. But the way around that, Your Honour, is my position on my client is that the accusations rejected ought to be dismissed.
I can hear you, but I've asked for submissions in writing. I'm happy for you to put anything you want to say in response in writing, and then a decision is going to be made about whether or not there is any time allocated for oral submissions.
Well, I'm raising the context, Your Honour, of whether the other parties have been informed of this. I don't act for them, I said that on the first day.
Sure. So if you want to have a discussion with counsel assisting about, in fairness, who should be notified, I'm very happy for you to have that discussion with counsel assisting.
Yes, Your Honour,
And if you're not happy with the information that is relayed, then it would be an appropriate time to raise it in court time.
Your Honour, I'm just simply raising this point. What Mr Bowe says, if you're not proposing to make the referral confronting the party any further, that's the process in which he steps out in his submissions, which means other parties don't need to be heard, submissions don't need to be filed, and you can make your decision about whether they're being proposed, and that might dispel the matter. I'm just simply looking at it from an efficiency point of view. That's all I'm raising for you.
Thanks. We're adjourned till 9:00.